Hello.
Hi there, is that Mr. Dawson?
Yes, it is.
Hi there, it's Katie Wood from Court Services Division. How are you?
Good, thank you, and thank you for calling me.
Oh, for sure.
So,
How can I help?
I would like to speak to you about my complaint I sent to you, and I'd like to speak to you about your responses.
Sure.
First of all, I'm just wondering, what is your role with the Ministry Attorney General?
So I'm an Assistant Deputy Attorney General. That means that I run the Court Services Division, which is really responsible for the non-judicial side of the court system. So that is behind the counter, in-court support, programs that you see in courthouses like family mediation services, for example.
So you said court administrators?
Yes.
So I guess you're the person. Well, okay. So I guess yeah. So when you have court administrators that have been caught engaging in blatantly disregarding the rules and the laws for accepting materials, and it harms people, I guess you're the kind of fall down person, maybe, or the fall person.
I'm the person responsible for liaising with the court offices and trying to determine what occurred and whether or not any remedial steps need to be taken.
Who did you discuss? You said in your email. I got my email and I got both of your responses up. But who did you? You said you discussed these specific concerns. Or sorry, who did you discuss the specific concerns with?
So the Director of Court Operations and the Manager of Court Operations, James Doby and Jessica Rose.
Okay, and what location do they work out of?
So the West Region, and Jessica is the NCO. Sorry, I'm going to have to just remind myself that so many people have...
Yeah, no, I didn't even know about these people because I thought they might be working out of your location is at Bay Street.
So let me I'll explain the structure if it helps, but let me just make sure I am giving you the right information.
You said the director and the regional...
So we have 7 regions in Court Services Division.
Okay.
And so you're talking about the West Region. I would be hard pressed to verbally explain without a map, but...
No, I have an idea. I'm just... who's in charge for that region?
So that's James Doby. He's the Director of Court Operations. So every region is led by a Director of Court Operations who's responsible for managing, who has a number of... every courthouse then has a Manager of Court Operations.
Sorry, is that D-O-L-B-Y?
No, D-O-B-I-E.
D-O-B-I-E, okay. And you said there was like a female? Was it a female's name?
Jessica.
Yep.
Rose, R-O-E-S.
Okay.
She's the Manager of Court Operations, at the very least in Kitchener, but I'd have to look at her other locations as well.
Okay.
So there's always a director and then a Manager of Court Operations for every courthouse. Sometimes they have more than one courthouse, the manager. And then there are supervisors under the managers who are responsible for court staff. We have 3,500 staff in Court Services Division.
Right.
So it's a structure that's necessary to provide adequate coverage with that volume of people.
Right. So I'll go over some of my complaint that I sent you, but basically, I got unlawfully dragged to family court with a woman I was never married with, had children with, or lived with. No domestic violence, no police history. This courthouse accepted a restraining order application that was commissioned and unsigned. We know that's not allowed, and that's a big no-no. That should, and not only that, I was unlawfully forced to go into a trial without a trial schedule endorsement form ever filled out, served, and filed, and that's under Rule 17, Sub-Rule 11. Mm-hmm. So those are two of many issues that need to be resolved, and I don't think it's appropriate just to send me on my way and not doing anything about it if you are responsible for this type of court administration misconduct, because that's what it essentially is.
So I would disagree with you that it's misconduct. I think staff where there are deficiencies, in most cases, will refer those deficiencies to a judicial official to determine if they're fatal or violent.
No, come on. You don't make me laugh in the beginning of this phone call. If you're going to have these individuals apply for jobs through the Ministry Attorney General, and they, you know what I mean? This is common sense. It's like, I'm an electrician by trade. There's codes and rules that I must follow. If I don't follow those rules, people can seriously get injured. And that's essentially what's happened to me. You've got a handful of court administrators that just were either incompetent or just took instructions to do this to me. And now, not only my reputation, but my finances have been seriously damaged because of the lack of respect for abiding by the rules and the laws that these court administrators should have been abiding by.
So I understand that that's your position.
Okay.
I really do. And I've thought about, sort of
laying the hammer down and holding them accountable for not abiding by the rules and the laws, the basic rules and laws that they are supposed to. Look, like, we've got this justice system that can be very dangerous and it can injure innocent lives, and that's what's happened to me. Okay?
Yeah.
You know, and you know what? Right now, this is falling on your table, and it's there's a lot of live issues here that need to get sorted out, and you like dismissing what I sent to you and not really answering to it is not appropriate. You've made a huge mistake here.
Fair enough. I understand that you feel that way.
It's not that I feel like I if you don't mind, it's not about feelings. This is about laws and rules. So this has nothing to do with feelings. This has to do with you're responsible for court administrators who don't follow the rules and laws. And when they don't do that, lives can get damaged. Just like me as an electrician, if I don't properly ground and bond things, someone can get electrocuted and possibly die. So we need to uphold the rules and the laws. And these court administrators didn't do that, and you seem to be supporting this misconduct without any proper disciplinary actions.
First of all, with respect to disciplinary actions, if there were any, in any circumstance, those would not be steps that I would disclose. Those are labor relations related, so I would not be disclosing that. That being said, with respect to the particular filings here, I think the difference between what you're talking about with not following the rules and following the rules is court staff determined that they could not make a determination as to whether or not the deficiencies were of such an extent that they should refuse filings, in which case they sought a judicial determination.
An application was commissioned without a signature. You really want to defend that huge error? What about listen, a trial... Sorry, I don't mean to say listen. I'm obviously frustrated. I don't mean to be rude towards you because you're apparently trying to help me. And I'm hoping that you can provide a little bit more help than you've already done. But you cannot file a schedule. A trial schedule coordinator knows this. This is basic common sense. I was already told by Salone French that Justice Tweedy told her to schedule a trial anyways, when the trial coordinator, Salone French, should have known this because this is her job, with scheduling trials. And if that form is not properly filed with the court or even served, they cannot legally, by law, schedule a trial. So, you know what I mean? You want to defend that as well, or do you want to just call a spade and say, yeah, they screwed up big time?
Can I ask you what it is? I don't want to sound disingenuous in asking this question. I'm really interested in the answer in terms of what it is you're hoping to see with respect to an outcome here.
So can you comment on that restraining order application that was commissioned and unsigned that your court clerks accepted? And can you also answer to this trial schedule endorsement form that by law must be filled out, served, and filed before any trial is scheduled? And you can check that under Rule 17, Sub Rule 11. Can you please explain these two major administration errors that caused significant damage to me? And can you either, like I said, call it a spade and say, yeah, they screwed up, they made a mistake, or provide an explanation to defend them a little bit more? If that's,
I think I have. I mean, the explanation is that where there is uncertainty as to whether or not they should accept a filing, and I know you disagree as to that uncertainty. I hear that loud and clear. But where they are uncertain, they submit the filing to a judge for a determination, and the judge makes a determination, and we act at the direction of the judiciary. Well, I know you don't like that answer. I understand that, but I'm telling you the truth. That is the answer from my perspective. I wouldn't have directed them.
I just want to let you know this. The trial judge was handpicked. He's the only judge only judge in Ontario sitting in the Superior Court who has his judicial training from the Canadian Armed Forces. There's a lot of rumors going on about corruption in that courthouse, and I can tell you firsthand, when I went to that trial, I was given less than 24 hours notice from your court admins about this trial on February 6, 2024. It was a 2-day trial. I brought all these procedural violations up to the judge, and he said, we're here now, we're going to deal with it.
Right.
At that court proceeding, there was another affidavit that was commissioned and unsigned, and this judge lost it on the lawyer. John David Ekpignon, you can Google his name. He's actually being prosecuted by the Law Society Tribunal right now for some of this stuff he's been doing. They admitted to paying $7,000 on a commission unsigned affidavit. This judge lost it. When I lost that 2-day rigged trial, with that this judge had no regard for these procedural violations, they submitted a fraudulent bill of $160,000. This judge knows that they didn't pay that. This judge ordered me to pay $60,000 3 days after my 40th birthday. 60 days later, without any communication, this lawyer started a garnishment application. I have 20 emails begging and pleading to make payments. He refuses to. My bank accounts have been frozen since September 2024. And if your court administrators had done their job properly, this application should never even gone through this process. But because of you and your colleagues that don't want to abide by the rules and the laws that you are all sworn by the Attorney General of Ontario to abide by, to enforce an impartial court proceeding, if you don't abide by that, lives can get seriously damaged and injured like mine did. And I believe all of this misconduct falls under your authority.
Can I ask a question? I'm just wondering, because your concerns are with outcomes in particular. I know you're very concerned.
No. I'm more particular with the court administrator's conduct. This is what we're talking about. It has nothing about legal advice. It has nothing to do about the outcomes.
Okay, fair enough. So you know where I was going with that?
Oh, yeah. Where you guys all go with it. We can't give legal advice, and if you want to appeal, none of my materials in my complaint is questioning the outcome or asking for legal advice. It's solely on the blatant disregard and ignorance of these court administrators in the Kitchener-Waterloo courthouse.
So there's nothing more I can add about that particular piece. You and I disagree about it.
Well, I'm asking your comment about the court administrators who accepted an application.
Mr. Dobson, I commented.
Okay, but what was your comment? You didn't. You kind of turned it around with your response.
Sorry, if it's not clear, my comment is that court staff, where they are uncertain as to whether or not all of the requirements have been met to file a document in a particular case, are to attach a notice of deficiency to that document and give it to the judge for judicial determination. Okay,
so how do we determine if that information was included? How do I get a copy that what you just said, that the court administrators made a note saying, hey, we have an application, it's commissioned and unsigned. Am I able to get a copy of this? Because if that is not included, then we know even further about this issue.
That's a really fair question. I will ask that question and see what we can do in that regard, for sure.
Well, not just that. What about this trial schedule endorsement form that by law must be filled out, served, and filed before any trial scheduled What about that? So you're telling me that this court administrator said, "Hey, I'm going ahead and I'm filing this trial. I'm gonna schedule this trial without that form." So that you're telling me then that should be included with scheduling the trial from Sloan French.
Yeah, I think the issue there is, my understanding is that that was at judicial direction, and we are required to follow judicial direction just like any other person.
So what about the rules and the laws? If the laws say that, so are judges above the rules and the laws?
No, I'm not. But this is where we part ways in terms of you don't want to hear the answer to that.
No, but I want to know. Okay, hold on. I just want to know: are judges above the law?
Absolutely not.
Okay, so if there are rules, the rules and laws, if there are rules and laws, what's the point of having them if court staff and judges refuse to abide by them?
There are appeal processes where someone is of the belief that a rule or law has not been followed and a judicial determination was made wrongly. That is what an appeal process is for, or a judicial complaint process is for.
Okay, so are you familiar with the Canadian Judicial Council?
I am.
Do you know that, have you seen their 2024 annual report?
I don't believe I have.
So they dismissed 100% complaints and gave 3 warnings. They received $3 million from Canadian tax dollars. So clearly filing complaints with them do not work. And filing complaints with you don't work either.
Are you in the Ontario court or the Superior Court?
Superior Court.
You're in the Superior Court.
Yeah. So obviously, statistically, filing complaints do not work with the Ministry Attorney General, and filing complaints do not work with the Canadian Judicial Council. So do you handle complaints against court administrators?
Against court administrators, but not. Sorry, this is going to sound. I don't mean to sound like I'm giving you a runaround here. Not against trial coordinators. Do not work for Court Services Division. They work on the judicial side.
So is there some type of report that I can request how many complaints you get and how many you dismiss?
I don't think there's an existing report.
Like a freedom of information? Is there something?
You could try to file a freedom of information. I'm wanting to think about that before I put you through the trouble of it.
Well, I would put your title, your job title, your name, or your department, and complaints filed through you and your team, and whatever's available, I guess.
Yeah, you could do that. There is not a formal complaint process in place in the same way that there would be for like the Canadian Judicial Council, for example. So you're not going to get the same kind of results you would through that avenue. For sure, I don't want to give you advice about it because I'd have to think through what existed in a response. But it's, I think, a question. Like, I don't have an answer at my fingertips, or I would give it to you. Failing my having an answer at my fingertips, it certainly is. The FOI process is a process that's available to you. I'm reluctant to encourage you to do it and to get a no because I haven't thought through exactly what it would look like. But it's absolutely open to you, and it may yield the kind of results you're looking for. It's possible, for sure.
Okay. Just a couple things here. I won't take too much of your time, but in your response, I think this is all from March 23rd, you said that you identified that all court service division staff must adhere to impartiality, court rules, and minister policies. So if they are caught engaging in violating the court rules, the ministry policies, and not being impartial, what normally happens if there's compelling evidence of court administration abuse and misconduct?
It would depend on the circumstance. There's no single answer to that question. Disciplinary action is there's a potential for that if there was found to be a violation of those principles.
So would that be something else to apply for through the Freedom of Information to see actually how many court administrators you...
No, I don't think you can access labor relations information through the Freedom of Information Act.
Okay. You say in your email, you say you confirmed several errors and deficiencies received appropriate notice to the presiding judges.
That's the notice of deficiency that I'm talking about.
So what deficiencies and errors were made by the court administrators?
Sorry, I think we were referring to deficiencies and errors in the material filed.
Right.
So where material was not, where all material was not made available, we flagged with a notice of deficiency.
Okay. So you say also to this last thing for this email that you say some of the concerns are outside of court services. Well, which concerns fall within the court services that you've noticed that there's been some type of error?
So the concerns that you identified with respect to what court staff accepted at the counter or otherwise in terms of filings, that absolutely does fall within our jurisdiction. But I have satisfied myself that they took the appropriate steps to flag those notices of those deficiencies to judiciary.
Okay.
What is outside of our ambit are things that occurred as a result of judicial direction.
But you don't know if they took the necessary steps. You don't know that. You said you don't know if they took the necessary steps and left and made a note on these submissions.
It's true that I haven't gone through.
So how can you make that statement? This is the problem. This is one of the issues I'm having with your emails and the way you handled this. You're sitting there saying that you're satisfied with how they've handled it, but you don't even know if they had these notes included.
So I don't know this particular practice in the location, but I am satisfied that they flagged the deficiencies for the judiciary. So
But you don't have confirmation, though. You don't know. You're just making that up.
I am not making that up.
So you've seen proof? You've seen proof of this?
I have had conversations with management in that location who has provided me with assurance that that is what has taken place.
Okay, well, don't see any assurance, and I don't see any proof that this was done.
So I will look into whether or not there's anything that we can provide you in that regard in terms of the steps that were taken. I think that's a fair question, and I will look into it.
Carrie Rice, operations manager, she's the one that really needs to be disciplined and investigated, and maybe see full public scrutiny over her actions. But with Carrie Rice, she's refusing to release audio recordings of proceedings I was a part of because she's saying I was labeled vexatious against two people. We both know that that's not true. That just because you're labeled vexatious, that does not mean you can be denied audio recordings. We both know that if you're labeled vexatious against a certain party or anybody, all proceedings are stopped, they're stayed, and you have to ask permission to restart them. I don't need permission for my audio recordings.
Yeah, I'll look into that as well.
I thought you looked into this, though. You said this in your email.
Audio recordings piece, I did not specifically look into.
Okay, I'm reading it right now. You commented on those. You commented on them. I think it was in your email. That's why I have these open. Okay, right here. Please note that some of your concerns are outside of court services control and fall under judicial discretion, including decisions relating to the release of audio files, which you're telling me something completely different.
Right, I thought I did not understand that was a judicial decision. I thought you were saying that Carrie Rice made that decision.
No, she did make that decision, and she's trying to be slick, we'll say, and referencing section 140 and saying that you need to read that section, you've been labeled vexatious, you need to ask for permission. I'm like, no, I don't. It's simple. Like a layman knows this. If you're labeled vexatious, and I just explained that to you. So
I understand what it means to be vexatious.
Right. And I'm not, and this is the other problem too with this courthouse. That vexatious litigant application was left at my doorstep. That is not proper service. Again, do you see how this is seriously, catastrophically injuring me? Because if your court clerks are accepting an application left at my doorstep, and I can even tell you right here, under the Rules of Civil Procedure, Rule 16.3, 5A and B, which I've sent to you in my original complaint, you cannot leave an application at someone's door. You must hand it to an adult. They did not do that. So what happened was 3 motions went ahead, and this lawyer didn't even confirm any of his motions. And that is another rule. That falls under 37.10(1) and 4. If you do not confirm your attendance, the proceedings do not commence. And your court staffs, I've scheduled them every single time without confirmation of this lawyer's motion, of an application you left at my doorstep. I don't think, listen, Katie, I don't think you realize where I'm going to take this situation. Like, this needs to receive full public scrutiny if you are not going to reconsider evaluating my complaint and holding those accountable. Like I said, I'm an electrician by trade. If I don't do installations properly and safely and by code, people can get seriously injured, if not die. Mm-hmm. And you are not, I'm not satisfied with your correspondence, and I do appreciate you called me and that we got to clarify this, but I'm not going anywhere.
Yeah, I hear you. You've given me some a lot to think about. I'm going to take some of the things away.
No, I want a reconsideration. I want every bit of information through the Freedom of Information. I want you to follow up. I want the audio recordings. I want every single audio recording unredacted from that courthouse, and I don't want Carrie Rice telling me that I can't get them because I've been labeled vexatious against 2 people who left an application at my door that your court administrators accepted, ran 3 motions without Ekping Young, the lawyer, is being prosecuted by the Law Society Tribunal, to commence. This is now going to be an issue for the court administrators. And I can almost tell you certainly, this is going to be a national story. And I'm going to be honest with you right now, this whole phone call has been recorded.
I anticipated that it would be.
And I'm only doing that because this is like we're auditing. Okay? I'm not here to give you a hard time, and I apologize if I raise my voice or sound like I was yelling. I'm not. It's not your fault. But you have the authority over this situation. And it's either you're going to do something about it or you're going to try to bury it and defend it.
So you don't have to apologize to me. I appreciate your taking the time to spell it out. I need to take it away and do some thinking about what you've said, and I will get back in touch with you to provide you with a follow-up.
Well, I think between my complaint, your correspondence alone is in the public's interest. And I'm going to respectfully, not sound like a jerk, but I want to give you another opportunity to really think about the authority you have, the misconducts that have been caught. We're talking about I'm looking at the rules, some of the rules, and basically what I'm asking for you, I want access to all of my audio recordings because what they're doing is wrong. They're lying and they're trying to finesse me. There was a couple other things you were going to look into. There was that.
Yes, it's okay. I have notes.
Do you? Okay.
I'm sorry. I have another appointment. I will do the things that I said I would do, and I will get back to you. I know you will follow up with me.
No, I'm not. I'm going to wait for you to say what you have to say because do you ultimately report to Doug Downey?
I report to the Deputy Attorney General.
The Deputy Attorney General. Okay. The Deputy Attorney General, because there seems to be a pattern of this type of service, and considering $2.1 billion were allocated to the Ministry of Attorney General last year, this is unacceptable from a taxpayer's point of view. And I really hope that you're going to do something different than what I'm reading from your emails. I'm expecting a different outcome, and I do appreciate your time.
Thanks, Mr. Dobson.
Thank you.
I'll be in touch.
Thanks.
Okay.
Bye.
Bye-bye.